Assalamualaikum and hello everyone. In this video, we want to present our group assignment for subject Real Estate Law 2 BPE 20603 and we are from section 1. The topic of the review we have chosen is issues pertaining sale and purchase agreement in Malaysia. First of all, let me introduce my group members. My name is Misha Razika and the other members is Nur Fatin Amira, Lina Nabila, Kristina Nur Aisyah, Muhammad Rahman and Syed Iqbal Faris. Introduction. The Sale and Purchase Agreement SPA stands as the cornerstone of real estate transaction, embodying the legal framework that governs the exchange of property between parties. In the Malaysian context, the SPA plays a pivotal role in ensuring transparency, protecting the interests of both buyers and sellers, and maintaining the overall integrity of the property market. This research aims to delve into the contemporary issues surrounding sale and purchase agreements in Malaysia, shedding light on the complexities that stakeholders face in ever-evolving market.
In this video, we are able to review 5 cases of sale and purchase agreement in Malaysia. First is Pang Shu Ming versus Kosher Home Sdn Bhd. Second is Lu Chu Teng and Ano versus Chok Swee Lee and Ors. Third is Wong Siu Chong versus Unvest Corporation Sdn Bhd. Next is Wong Kup Singh versus Jeram Rubber Estate Ltd. And lastly is Diamond Development Sdn Bhd versus Matthew Liu.
Firstly, in case 1, Pang Shu Ming vs Ketua Home Sdn Bhd. In this case, it is about the defendant applied to strike out plaintiff writ and statement of the claim, whether the defendant fulfilled contractual obligation under the sale and purchase agreement, and whether plaintiff claim unsustainable of court's process. The issue is about the plaintiff, which is Pang Shu Ming, bought a commercial unit called LG30 from the defendant, but claimed the defendant unlawfully changed it without their knowledge. The LG30's original placement had been replaced by the switch and meter room and the struts. The plaintiff claimed this breach of the original contract. The defendant argued that the parcel was relocated as LG29 due to a building plan revision granted by MPSJ in 2009. The law, the defendant can amend, vary, substitute or reconstruct the parcel without seeking consent from the plaintiff. In Section 13 of the Housing Development Control and Licensing Act 1966 and Housing Development Control and Licensing Regulation 1989 state that no error or misstatement in the description of the parcel can annul the sale or entitle the purchaser to be discharged from the purchase. So the conclusion is, to sum up, there should be convincing proof that the original unit had been taken over by utilities or being used as a common property and that is no longer used as a unit. The court ruled that the defendant can charge a unit without consent from the plaintiff. On the same terms, the plaintiff must accept any alteration because its position and description are not guaranteed to be correct. The court established that parties are obligated by contract terms and the defendant met its contractual responsibility by providing LG29 with similar dimension.
Next, Lu Chu Teng and Ano versus Chok Swee Lee and ORS. The issue, the plaintiff entered into an agreement with defendant and one Ong Tai Hong as additional trustees of the deceased estate to purchase a piece of land held under lot number 532 Mukim 12 Southwest District Penang. Clause 5 of Sale and Purchase Agreement states that the agreement shall be null and void if there is refusal by the government to release the subject property from compulsory acquisition, and Clause 8 states that the trustees shall apply to court for a formal sanction to sell the property. The law, the court used Probate and Administration Act 1959. This act deals with the administration of the estate of deceased individual. It typically outlines procedure for obtaining probate, legal recognition of a will or letter of administration when there is no will, and govern the distribution of assets among heirs or beneficiaries. Evidence Act 1950 and Specific Relief Act 1950. Conclusion. The defendant filed an action against the plaintiff in 1981 for specific performance of an agreement dated 8 January 1979. The agreement between the plaintiff as vendor and the defendant as purchaser for the sale of a piece of land at RM RM1.60 per square feet. In the instant application, the plaintiff apply for permission to sell the land at the market value of the land at the date of approval.
The third case review is about Wong Siu Chong Sdn Bhd versus Envos Corporation Sdn Bhd. The plaintiff, Wong Siu Chong Sdn Bhd, has several plots of land in the Kuala Lumpur district. The land was transferred to the defendant, which is Envos Corporation Sdn Bhd. When the land was claimed by the plaintiff, the defendant issued a writ against the plaintiff for wanting to reclaim the land. The writ issued by the defendant is intended to seek damage for the breach of contract made by the plaintiff. While this case was proposed in the court appeal, the defendant applied to the Supreme Court to make a specific performance of the contract by the plaintiff. In this case, after getting the decision of the Court of Appeal, which has been confirmed by the Federal Court, this case is beyond dispute that the valid contract of sale on the said land to the defendant. The land to be sold has a total area of 100,934 square feet with total purchase price of 5,551,317 ringgit. From the case, a small portion of the land has been used as compensation amounting to 5,252,783 ringgit and 20 cents, which has been paid to the plaintiff by the government. To summarize, the appeal of the plaintiff which caused here and below and set aside the order of the land judge, the deposit is to be refunded to the plaintiff. In this case, be remanded to the High Court regarding the proper order to be made for the completion of the contract between the plaintiff and defendant.
Next case is Wong Kup Sing versus Jeram Rubber Estate. In this case, the issue is the plaintiff Wong Kup Sing is seeking specific performance of an agreement for the sale of a rubber estate as he is a land proprietor. The plaintiff is claiming damage for breach of contract. The defendant, that is Jeram Rubber Estate, is agreed to multiple extension of time for completion. On 15 November 1967, the defendant informed the plaintiff solicitor that no further extension would be granted. They insist that the purchase be complete by noon on that day or the agreement would be terminated and the plaintiff deposit will be forfeited. So, in the law, the court held that once the convention date had passed and the parties continued to negotiate, time was no longer of the importance of the contract and the defendant must give reasonable notice of their intention to terminate the contract if the balance is not paid. Secondly is the notice of abandonment date 15 November 1967 was not a reasonable notice. Under the circumstance, the plaintiff had established a case for particular performance of the contract. In conclusion, the defendant failed to provide the plaintiff reasonable notice that they intend to terminate the contract after agreeing to an extension of time for performance of a contract. Lastly, the notice of abandonment date 15 November 1967 was not a reasonable notice and the contract was never terminated.
The next case is Diamond Development Sdn Bhd versus Matthew Louis, 1981. The issue is the appellant raised the house price to RM35,100 due to change in building plan and construction cost. The respondent object, and if the deposit was not paid, the booking would be cancelled. The purchaser rejected the revised price and sued for specific performance of the pro forma agreement. The Lordship ruled that the appellant were bound by the pro forma and the respondent was ordered to pay the balance. The law is the court ruled that the booking pro forma was a firm contract, identify parties and specifying properties and price. However, the appellant were bound by the Housing Developer Control and License Rule 1917 and had no right to change the price. The conclusion is the defense argued that the booking pro forma, which required a sale agreement, is subject to contract and cannot be considered a complete agreement. The plaintiff argued that the defense evidence do not support this, and the pro forma grant an irreversible option to buy the property at the state price. The case centered on the housing developer control and license provision.
In conclusion, the sale and purchase agreement, which outlines the right and obligation of both purchasers and sellers, is a fundamental document in the complex world of real estate transaction in Malaysia. All parties involved should give serious thought to the complex interplay of legal, economic, and practical concerns that arise from this investigation of the issues surrounding sale and purchase agreement in Malaysia. That's all from us. Thank you.